joining the legal fraternity. He was with Deloitte in their restructuring and turnaround team. He's graduated from Tamil Nadu National Law University, and he's also done his postgraduate insolvency from the Indian Institute of Corporate Affairs. Over to you, Venkateshwara.
Thank you. Good evening, everybody. My name is Venkatesh, and as said, I'm an advocate and I'm a registered insolvency professional as well. I have completed my graduation from the Tamil Nadu National University, and after that, I did my postgraduate from the Indian Institute of Corporate Affairs in insolvency program. And I would like to thank the Madras Tax Bar for giving me this opportunity to give this presentation on tax prosecution. I would want to thank all the seniors here, and I would want to thank my senior, and I want to thank God ultimately. And I'll get into the topic. My topic is about the tax prosecutions. And importantly, I will be covering on the jurisprudential foundations to the current contemporary challenges that are currently there in the tax prosecution laws in India. And I think every tax practitioner begins his career. This is how I started. This is my story also. I think every tax practitioner starts his career by understanding the legal terminologies such as what is a capital gain, what is a presumptive income, how an assessment is done, and slowly one gets into the depths of the water by understanding how the assessments are challenged by the department. Ankle length, and they will understand how the department is nitpicking all these issues out of the challengement. And once we are slowly, confidently getting into it, neither will be understanding how to defend these tax prosecutions as well. However, at a certain point during this practice, one will come to a realization that the state is not simply asking how much tax is payable. Rather, the state is asking that has there been a crime committed due to this tax evasion? Has there been a serious offense because of this tax evasion or failure to furnish return of income? I believe this transition from a civil dispute to that of a criminal accusation is the jurisprudential foundation of tax prosecution laws in India. And to make us understand in more depth manner, I would say that taxation, I mean assessment, penalty, and prosecution are not three different stages of a taxation of the same taxation process. Rather, I would say that these are all three worlds in itself. These are three different exercises of sovereign power. These are three different modes of tax regulation in India. This assessment it determines liability, penalty enforces the compliance, and we have prosecution which condemns the conduct. And this distinction is fundamental because in criminal law, it is not. I mean, the criminal law it's not concerned merely with what is done, but is also why it is done. So this further stems the question that why does a tax statute even constitute a criminal provision in the first place? In order to answer this question, I think we need to leave tax statute a little bit and we have to see why is there punishment in the first place? Why should there be criminal provisions at all, even in the criminal law? Then I think we'll have a better understanding of why a tax statute should constitute a criminal provision. And for this, I will throw light on the philosophy of punishment, the classical criminal jurisprudence. And before getting into it, I would like to give a little tribute, and I would like to talk about this person on the screen, who is Oliver Wendell James. He's a U.S. jurist. He's one of the first and foremost well-known proponents of legal realism. He propagated that law is not a static set of rigid rules. Rather, he told that law is a living, evolving organism, and it evolves with time. Slowly, one gets to see how law changes. Also, this is what he has told. And in order to understand why does a tax statute create a crime at all, I would want to talk about the four theories of philosophy of punishment. First is the retribution. Retribution is the most primitive, or I would say most the most oldest and the most intuitive and impulsive theory that will explain the philosophy of punishment. Retribution is basically just a revenge. It put simply, it is just an eye for an eye. A person seeks an eye for an eye because he has lost an eye, and It is that this retribution theory of punishment tries to explain punishment by saying that a moral outrage has happened, it has been evoked, and it is justified, but by only an equally justified moral outrage. If we see this, if we see tax prosecution in the lens of retribution, I don't think this retribution theory of punishment will explain tax prosecution, because there is no actual revenge happening in this instance. Of course, there is the person, the public exchequer who is being who has lost things, but then the moral wrong has been diluted so much that the tax evasion does not evoke the same moral outrage as that of a murder, rape, or a terrorism. Then we have the theory of incapacitation, which is about removing the fringe element out of the society totally. This again will not be explaining the tax prosecution's philosophy, because there is no such evocation of moral outrage. I think the best suited philosophy to understand tax statutes are deterrence and reformation. Deterrence convincingly explains the tax prosecution. The theory of deterrence can be associated most prominently with Jeremy Bentham, whose utilitarian philosophy viewed punishment as a necessary evil. Why should there be a necessary evil? A necessary evil should be there to prevent a greater evil. And in this instance, say for instance, a person would want to, a person, an assessee wants to conceal 100 crores. The upper limb of the right. A person wants to
in the subject GST.
Yeah, you can unmute yourself and start. I muted all.
If I was explaining the theory of deterrence, it is the theory of deterrence, to simply put, it is the prevention of furtherance of a crime. There can be two deterrences happening. There can be two types of deterrence. One is specific deterrence, and another is general deterrence. Specific deterrence is when a wrongdoer is punished so that he will not repeat the wrongdoing again. And general deterrence, it is when the other public, the people surrounding by, see that the person who has been punished and they themselves prevent the wrongdoing. They themselves don't do it in the first place. Suppose an assessee deliberately conceals hundreds and crores of income, and upon detection, the tax is recovered, interest is recovered, and penalty is also imposed. But now, here the question arises is that why should the government prescribe imprisonment? For instance, we have section 276C, which prescribes imprisonment when the government can simply recover tax, levy interest, and impose penalty. But again, as Jeremy Bentham told, there needs to be a necessary evil to prevent a greater evil. We cannot just let the man go by paying what he has stolen. Then it becomes a commercial gamble. The downside of it becomes manageable, while the upside is that he can get away with the hundreds of crores of income. And for this specific reason, this is what economists also call as a perverse incentive. And in order to stop it, only we have imprisonment for prescribed for certain sections, such as section 276C. Then there is reformation theory, which the modern criminal jurisprudence talks about. Reformation is asking this question whether the person who has done a wrongdoing can be brought back into the society. I think the tax prosecution laws currently do follow reformative theory, because they have the settlement schemes, they have voluntary compliance schemes, which is actually buying peace, and then to come back into being into a civilized society. Now that we have understood the why behind the tax prosecution, I think now we can go to the what are the sections and which are the sections that talk about tax prosecution. As I said, there is a dual enforcement mechanism in the tax prosecutions. One is quasi-criminal and another is purely criminal. For example, penalty proceedings are quasi-criminal, even though they start as a civil wrong. It has the color of a criminal wrongdoing also. While we have these prosecution proceedings which are purely criminal in nature. The object of both of them is very distinct. First one, the penalty proceedings, is to just ensure compliance and to recover the lost revenue or to recover the stolen revenue, while the prosecution proceedings is to punish the willful and serious violations. It acts as a deterrent, so that other people won't do it and people are discouraged from doing it. Then coming to the standard of proof, for penalty proceedings, we have the civil standard preponderance of probability. The department just needs to show that the likelihood of happening of a wrongdoing is more than that of it not happening. The department can go ahead and they can initiate penalty proceedings just with the circumstantial evidences and the surrounding materials as well. But for a criminal proceeding, the standard of proof is very severe and it needs proof beyond reasonable doubt. And talking about the forum, the statutory, the framework of the taxation laws itself gives for penalty proceedings. For income tax and GST, we have proper offices, which for which one can appeal before the appellate authorities, and thereafter one can go before ITAT or GSTAT as the second appeal, and eventually the case will end before the High Court or the Supreme Court. While in the criminal cases, in the prosecution proceedings, all the matters are being prosecuted by the state, and so all the matters go before the magistrate or the special court only. Then talking about mens rea, which is an conundrum that I'll be talking about in the further slides. But for now, the necessity of a mens rea in a penalty proceedings is a maybe or maybe not. It may not be present, but still a penalty proceeding can go on. But then in a criminal case, mens rea is an essential factor. Then the outcome, penalty proceedings will stop with just monetary penalty and financial obligations, while prosecution proceeding will go ahead and it will expose the wrongdoer to imprisonment or fine, to an imprisonment, which consequently will have a cost on his professional or social reputation also. Then I have given a slide of the statutory matrix, which sections under which acts talk about the prosecution. Under Income Tax Act 1961, we have section 275A to section 280D, and the administrating authority is Income Tax Department or the CBDT. Then we have GST Act 2017, for which the key prosecution sections are section 132 to 138, and the administrating authority over there is DGGA or GST Department. Then we have Customs Act 1962, which for which the prosecution sections are section 132 to 136, and the administrating authority is DRI. And even though PMLA, Black Money Act, and Benami Transactions Act 1988 are not taxation statutes per se, but they still form a part of the fiscal laws, and they have an interplay with all these three predominant laws. So I have written about that also. Key prosecution sections under the PMLA 2002 is section 3 and section 4, for which the administrating authority is Enforcement Directorate. Under the Black Money Act 2015, the key prosecution sections are section 48 to 53, for which again the administrating authority is the Enforcement Directorate. And then we have Benami Transactions Act 1988, for which the key prosecution sections are section 53 to 56. And again, the administrating authority is CBDT in this instance. For considering the brevity of time and the flow, I'll be majorly touching upon the Income Tax Act 1961, and I'll throw a little glimpse on the GST Act 2017, and then I'll be moving on to the contemporary challenges or the conundrums that I find that the legislature or the judiciary can address in the current tax prosecution laws. Coming to the Income Tax Act, I have given 5 columns. The first column is 1961 Act, the section number. The second column is 2025 Act and its section number, and then the title and the gist of what the section has to say, and the corresponding punishment to it. What I found is that in the 1961 Act, as well as in the 2025 Act, Chapter 22 speaks about the tax prosecutions, and almost all the sections are pari materia to each other. Going with the first section, it is 275A, which talks about contravention of order made during search action. Say, for instance, under search process, an order has been made not to alienate any property, and if an assessee goes against it and removes that property, he will be punished, and he'll be punished. He'll be given a simple imprisonment up to 2 years plus fine. Then we have 275B, which is about a failure to afford facility to inspect books or electronic records, for which rigorous imprisonment up to 2 years plus fine is given. Then we have section 276, which is pari materia to section 475 of the 2025 Act. This one talks about removal, concealment, transfer, or delivery of property to thwart tax recovery. We for this again the punishment given is 2 years plus fine. Earlier there used to be different imprisonment prescribed for different punishments, but lately they have liberalized and they have given uniform punishment to most of the provisions. We'll be seeing it, and we have 276B. I have bolded it because this is one of the most litigated sections under the income tax. It is failure to pay TDS to the credit of government. It is when an assessee detects TDS but then does not credit it to the central government. In that instance, the assessee becomes the trustee of the money which the central government is actually owed to, and he has failed to exercise and he has failed to deposit it to the central government. For which monetary threshold is given. It is said that if the TDS, I mean, the monetary threshold is given here, it is that if the amount not deposited is more than 50 lakhs, then simple imprisonment up to 2 years or fine or both would be given. If that amount is 10 lakhs to 50 lakhs, simple imprisonment up to 6 months, fine or both would be given. And if it is less than 10 lakhs, fine would just be given. Then we have section 276BB, which talks about failure to pay TCS. It is similar to that of the previous provision. Same monetary threshold is given for this as well. Then another one of the most litigated sections in the Income Tax Act, 276C. It is willful attempt to evade tax payment, tax, penalty or interest. And then we have subsection 2, which talks about willful attempt to evade payment of tax. The first subsection is concerned when there is an evasion during assessment, while the second subsection is concerned when the evasion is happening post assessment. For this also the same monetary threshold is given. Then we have 276CC, which talks about the failure to furnish return of income. Then we have 276CCC, failure to furnish return of income in such cases, self-explanatory. Then we have 276D, failure to comply with direction of special audit or valuation. Then we have 277, false statement in verification. The second half of the income tax prosecution chapter is where the interesting sections lie. For instance, we have 278, which talks about abutment of false written account, statement or declaration, for which the gist is that if somebody is abetting or if somebody is inducing another person to make and deliver false written or account or statement or declaration, they will also be given an imprisonment which can run up to 2 years. I will be talking about a conundrum with regards to this section in the later slide. Then we have 278AA, which is talking about reasonable cause. If there is a reasonable cause for failure in any of these sections, one can use that as a defense. The most used reasonable causes are third party negligence. Then we have severe financial distress. Then we have severe urgent medical emergencies. All these can be reasonable causes which can be used as a proper defense. Then we have 278B, offenses by companies. Vicarious liability is fixed here, and the people who are responsible for such act, namely the directors and the managing directors, they'll be put behind the bar, and the punishment will be corresponding to the substantive offense as per the section. Then we have 279, another important section, which talks about the sanctioning authority, which is given to the principal chief commissioner, chief commissioner, principal commissioner, or commissioner in order to initiate prosecution. There is also power to compound either before or after the launch of prosecution. That is also given in the subsection 2. Then we have subsection 3, which talks about the statement made or account made or document produced for penalty to be reduced, and these becomes an admissible part of the evidences. Then we have 278E, which I missed, which is about presumption as to culpable mental state. I'll be talking about one such contradiction in the further slides. One contradiction that I think is interesting enough to talk about. Then we have 280A and 280D, which talks about the special courts. The special courts for the instance of tax prosecution or or magistrate of first class, and the offences will be tried as per CRPC only. The CRPC, if it is a summons case, it will be like a summons case, or if it's a warrants case, it will be like that of a warrants case. Then two important guidelines we need to be looking when we are talking about prosecution, and when we are talking about tax prosecution, it is that the first one is CBDT guidelines on launching prosecution. That is circular number 24 of 2019, dated 9th September 2019. The object of this guideline is not as a, is that the object of this guideline is that prosecution should not be used as an investigating tool. Rather, it should be used only as a deterring tool. It should not be used as a routine measure, but only in cases which involve willful and serious offences. The guidelines direct the field officers to concentrate prosecution efforts only on certain sections, such as Section 276C, which is willful attempt to evade tax, then Section 276B and 276BB, which talks about failure to deposit TDS or TCS, then willful failure to furnish returns. The central consideration is whether the evidence demonstrates willfulness rather than a technical default. As the objective of the CBDT guidelines go, so it should be only used in the rarest of rarest cases. It should not be invoked in each and every case that the authority or the department is wanting to. Then we have monetary thresholds, which is given under these guidelines. It is 25 lakhs. And then we have the collegium mechanism, which is one of the most important institutional reforms introduced by the guidelines. It is that now, before sanctioning authority, the collegium consisting of two officers, two chief commissioners, or two director generals will need to approve the initiation of prosecution. If there is a conflict between either of between these both people, the overseeing authority would be that of the principal chief commissioner. This guidelines reflect a very calibrated prosecution policy, so that they treat criminal prosecution as a measure of last resort against willful and serious offences only, by prescribing monetary thresholds, requiring higher level approvals in specified cases, and linking prosecution in certain cases to appellate confirmation of penalty. The CBDT sought to balance deterrence with fairness and certainty in tax administration. Then one another guidelines that we need to look at if you are going to be dealing in tax prosecution is that of compounding of offences. That is circular number 4 of 2025. I would say that this compounding has become very liberalized after this circular number 4 of 2025 in a very neoliberal sense. The objective of compounding is not admission of guilt. Rather, it says that the nature of compounding, the nature of compounding under this guidelines, it is told that the circular clarifies that compounding is a statutory mechanism through which an accused is relieved from criminal prosecution upon payment of prescribed compounding charges and fulfillment of stipulated conditions. Importantly, the main objective, as it says, it is that compounding is not an admission of guilt. Acceptance of compounding application merely resolves the criminal proceedings and should not be construed as an acknowledgement by the applicant that the offence was committed. It is earlier, not all the income tax offences were compoundable. There used to be compoundable offences and there used to be non-compoundable offences. But under this guidelines, it has been made that all the income tax offences are now compoundable. Then earlier there used to be a timeline of 36 months to initiate compounding from the date of prosecution. But now that time limit has been removed. Then earlier only a single application can be filed, but now fresh applications can be filed if your previous application has been rejected. And if there is an issue that is running up to multiple years, then a consolidated application can also be filed. Then we have a very clear clarification on compounding charges as well. There is a clear-cut table which gives how much should be paid, when it should be paid, and how it should be paid. Then one can withdraw the compounding application also. Then coming to the conundrums, I think this is where I'll be spending a little more time. The sections were being rushed through, but this I'll cover a little more in depth. Coming to the first conundrum, it is constitutionality of reverse burden clauses under tax laws. if we see section 278E, 278E, it says that the presumption, the court shall presume culpable mental state and the burden shifts to the accused. If we look at the traditional criminal law jurisprudence, the presumption is that an accused is here, and the presumption is that the accused is presumed to be innocent until proven guilty, and it is the onus of the prosecution to prove that he is guilty beyond reasonable doubt. But here the taxation laws have gone a little 180-degree, and they have given that the onus is on the assessee himself to prove that he is not liable. Section 278 also provides an explanation to the section that clarifies culpable mental state. It says intention, motive, knowledge of a fact, and belief, or reason to believe, or a fact. Thus, unlike any other ordinary criminal laws where the prosecution must prove mens rea, the Income Tax Act creates a reverse burden in this instance. Once the prosecution establishes the foundational facts constituting the offence, the court is statutorily required to presume the existence of the guilty mind unless the accused reverts that presumption. Thus, there is a continuing debate of which I think is one that is concerned of balance. Parliament considers the reverse presumptions necessary because sophisticated economic offences are often committed behind closed doors. But still, that is not very convincing. I think this is one that needs to be addressed in depth by the judiciary and the legislature. Then the second conundrum that I will be covering is about prosecution and principles of natural justice. If we look at the provision 279, section 279, it provides for the sanction to be granted by the sanctioning authority, who are the principal chief commissioner or the chief commissioner or the commissioner appeals or a joint commissioner appeals. And this sanction is actually a precondition before launching of prosecution against any person having committed an offence. But significantly, this section is actually conspicuously silent on whether an opportunity of being heard should be given to an assessee before the launch of prosecution. There has been a strong legal battle that went on during 1990s, for which the dust was also settled by the Supreme Court. I'll quickly rush through the High Court's view and the Supreme Court's view on this, and my personal view on this conundrum. It is that the High Court of Delhi, in the case of Harnam Singh Suri versus CBDT, in 1984 set the ball rolling for this. It is said that when it was held that when the ITO, like an ordinary complainant, should not proceed to prosecute the assessee without giving him an opportunity of hearing. This stance was more elaborated by the High Court of Rajasthan in the case of Sri Singhvi Bro versus Union of India in 1991. It was said that principles of natural justice must be read into unoccupied interstices of the statute unless there is a clear mandate to the contrary, and that every process of quasi-judicial tribunals must inform itself of the principles of natural justice. It also goes on to say that the department has 4 options in the case of a prosecution. In case of concealment of income, the department has the authority to add the concealed income in the assessment of the assessee and can levy tax. Authority to levy penalty is there. There is the authority to launch prosecution, as well as there is the authority to go for compounding. Since there are 4 alternative remedies, and especially the remedy of launching of prosecution is at the option of the department, then in such a situation, it is all the more essential that the party should be afforded an opportunity of hearing before the prosecution is launched. The Karnataka High Court, in the case of PV Pai versus RL Renavma, went a step further and it touched upon the aspects of human psychology also. It held that an assessee may be anxious to offer composition even before prosecution to save himself from the disgrace and ignominy of prosecution. The person sought to be prosecuted may be an individual holding some position, a status in society or a company, an officer or a legal practitioner. Even when there is a willful concealment of income, such person may repent or out of fear of prosecution or of standing as an accused in a criminal court may offer to compound by accepting the terms and conditions which the compounding authority may impose. Therefore, simply because there is an opportunity to compound, after the prosecution is launched, it does not necessarily follow that such opportunity should be denied before the prosecution is launched. The stage at which such offer may be considered could be at the time the sanctioning authority considers the question of according sanction to prosecute. Therefore, the accused should be afforded an opportunity to be heard before the sanction is accorded under Section 279. This stance has been reiterated in the case of Dunlop India by the Calcutta High Court and in the case of Krishna Pipes and Tubes by the High Court of Allahabad. But there are contrary views to this also. There are views which are against granting the principle of audio alteram partem before the launch of prosecution. For instance, we have the case of Nirmal Kapoor versus CIT given by the High Court of Punjab and Haryana in 1979. It is held that Clause 5 of the settlement, in fact, reserves the right to the department to launch the prosecution and other penalties if the same was considered necessary and on the merits of the case. The aforesaid term by no means envisaged by any stretch of imagination that the department was to hear the partners again before deciding as to whether any prosecution was to be launched or not. We have our Honorable Madras High Court also, which went against giving the audio alteram partem principle in cases of prosecution. Expressed dissent from the decision rendered by the High Court of Karnataka in the case of PV Pai. The Madras High Court held that so far as provision under Section 279 of the Act is concerned, the granting of sanction by itself would not result in any punishment of the accused. Only for launching of prosecution, sanction was required. Then the matter is to be placed before the court, and it is for the court to consider whether the offences are made or not. The provision for sanction is only an additional safeguard against launching prosecution in all cases. This stance of granting opportunity of being heard was again of not being not granting an opportunity of being heard was again reiterated in the case of K. Balakrishnan Nair versus Assistant CID, and eventually the dust was settled by the Supreme Court, and they told that in the case of Union of India versus Banwarilal Agarwal in 1999 that there is no warrant in interpreting this subsection to mean that before any prosecution is launched, either a show cause notice should be given or an opportunity afforded to compound the matter. The enabling provision cannot give a right to the party to insist on the Chief Commissioner or the Director General to make an offer of compounding before the prosecution is launched. So it is now clear that the judiciary, the Apex Court, has given that there cannot be an opportunity of being heard. But I personally feel that we have the judgment of Menaka Gandhi, in which it is said that it is well established that even when there is no specific provision in the statute or rules made thereunder for showing cause against action proposed to be taken against an individual which affects the rights of that individual, the duty to give reasonable opportunity to be heard will be implied from the nature of function to be performed by the authority which has the power to take punitive or damaging action. If there is going to be any action by the department or the state which is going to render or which is going to yield in a civil consequences, in that instance only one needs to be given an opportunity of being heard. But then going a step further, this prosecution is a civil proceeding, so I believe it needs to be supplied into the legislation by the legislature, or at least the judiciary should be giving one such judgment in which this opportunity of being heard is actually made mandatory. But interestingly, starkingly, the department has laid down guidelines for launching prosecution in the Manual on Prosecution and Compounding 2020, which reads that although there is no statutory requirement for giving an opportunity of being heard to the person against whom prosecution proceedings is contemplated, however, such an opportunity shall be given by the commissioner. But departmental guidelines are departmental guidelines only. This explicit opportunity of being heard should be supplied into the legislation is what I feel. Then coming to the third conundrum, it is compounding of offences. Income Tax Act has an interesting approach for compounding of offences. Section 279 clause 2 gives for compounding of offences either before or after the launch of prosecution. But it is used that the expression used in the section is that the competent authority may compound an offence. So the use of the word may indicates that the power is only discretionary and not mandatory. And also it is clarified in the guidelines that the compounding is not a matter of right, but is only a matter of discretion. If compounding is choosing, if the income tax is choosing a very neoliberalized compounding mechanism, I believe that giving compounding as a matter of right would fetch more benefits to it. Then the last conundrum that I would want to touch is about the independent prosecution of professionals. When does an advice becomes an abutment? This issue assumes greater significance because recently I also noticed that investigating agencies such as DGGA or CGST commissionerates have registered cases and made arrests of advocates and other professionals allegedly involved in large scale fake invoicing and fraudulent ICC rackets. So this gives rise to a very important jurisprudential question, as in when does an advice become an abutment? However, the very fact of an arrest or prosecution does not establish criminal liability. There needs to be a strong criminal element in order to prosecute a professional. Currently, there is no authoritative Supreme Court decision which comprehensively defines the threshold for prosecuting tax professionals under 278. But then each case turns on its own facts, particularly whether there is an evidence of knowing participation in the fraud rather than the mere rendering of professional services. The contemporary challenge is therefore identifying whether legitimate professional represent where legitimate professional representation ends and criminal abutment begins. And then I have touched a little upon the Goods and Service Act. In it, Section 132 talks about the prosecution. It says that all the offences under, it is actually saying that all the offences under 74, such that of fake invoicing, supply of goods and services without invoicing, invoicing without supply of goods and services, are all cognizable and non-bailable offences. There is a monetary threshold for this also. If the amount if the amount of crime involved, if the amount involved in the crime is exceeding 5 crores, it is up to 5 years plus fine. If the amount is 2 crores to 5 crores, then it is up to 3 years plus fine. Then if the amount is from 1 crore to 2 crore, it is up to 1 year plus fine. GST also presumes culpable mental state on the assessee. It is again contrary to the classic traditional criminal jurisprudence. Then we have guidelines for arrest and bail in GST. Which is one important guideline we need to look when we are looking at GST prosecution. It again, like that of income tax guidelines for prosecution, it says that prosecution in a criminal proceeding is to punish only serious and deliberate violations. It cannot be used as an investigating tool. It can only be used as a deterrent tool. Prosecution is reserved only for serious offences, and it talks about the sanction for prosecution, the timing for prosecution, and the withdrawal for prosecution as well. Then I have listed down the common strategies that are currently used in the practice. One is pre-prosecution, and the other is, I have bifurcated in a way that one is pre-prosecution and the other is post the prosecution is initiated. If one comes to know about the launch of prosecution, I think the assessee should be readily able to quickly able to voluntarily complain, because it would show bona fide on the part of the assessee. If there is an Asian issue, the assessee should be replying to it on a timely basis. One can challenge the very sanction process, as in whether the sanctioning authority has given the right sanction, whether there has been a collegium signing on it, so on and so forth. The best way out is to file for compounding. The best way out is to just buy peace. But once prosecution is initiated, then one have a variety of defenses in their arena. One is to challenge the complaint at the very threshold. One can argue about the jurisdiction of the prosecution. One can go for bail strategy, either anticipatory bail or bail as and when required. Then one can also seek abeyance of prosecution proceeding until the assessment is done by the appellate outcome. However, such abeyance is not generally granted. One needs to strongly convince that they are strong on their assessment, so the prosecution needs to be kept in abeyance. Then we have strategic use of writ jurisdiction, for which the high courts may grant stay on the prosecution proceedings. Then I have listed down the common defenses that are used or that are employed in the tax prosecutions. One is absence of mens rea. One can prove that the wrong has happened without his knowledge or without his intention to do so. Then we have multiple reasonable clauses such as third party negligence, severe financial distress, urgent medical, urgent medical emergency, so on and so forth. Then we can say that the main adjudication is set aside, so the prosecution does not stand. We can always buy peace using settlement or compounding schemes. We can say that the sanction is very defective, and we can also go for no prior notice or no opportunity is being given. We can also talk about the vicarious liability defense. At the end, I want to say that if the taxes are the price of civilization, then the tax prosecution is the legal safeguard that protects the price from deliberate evasion. There are certain significant questions that remain unanswered, like that of how should courts balance the presumption of innocence with statutory reverse burdens? Should prosecution await the outcome of assessment or adjudication? To what extent should directors and professionals be exposed to criminal liability? These are not merely conundrums that are currently there in the taxation statutes or the vacuum in the tax prosecutions, but these are questions of legal philosophy and constitutional values. If the challenge, so now the challenge I believe is to for the lawmakers, for the administrators and the courts to ensure that the safeguard or the tax prosecuting mechanism is remains firm against fraud, but also it fair to the honest taxpayer. Thank you, everybody.
Thank you, Mr. Venkateshwar. In fact, of late, especially in GST, we are seeing a lot of arrests being made. But how many arrests are converted, further charge sheets are filed, and the prosecution is launched, we don't know. Mostly, this arrest is used as a threatening measure to extract the tax demanded during the course of investigation. You have covered the subject comprehensively. And how to deal with the prosecution. There are a lot more issues. You have explained clearly the legal provisions under direct tax laws as well as indirect tax laws. And we plan to conduct these kind of seminars almost every alternate Friday, wherever it is possible, to give a platform to mainly to our youngsters so that they come forward and discuss openly about the subject. And I find today the participants are also mostly youngsters. Many seniors have not joined. So we will try that most of the seniors also join and encourage the speakers. And one of our members, Mr. Anthony, is very much interested in this topic. He always used to put some kind of questions on this aspect in our WhatsApp group and all that. Now I request Mr. Anthony to join and share his views on this topic, maybe for 5 minutes. Mr. Anthony, you can
Yes,
unmute.
yes. Yeah, thank you, sir. Thank you so much. Okay, few points I wanted to discuss, but that is not covered in this topic today. So those many of the topics I wanted to cover, I shall not be speaking now. But basically about the prosecution, there are two things. Firstly, the threshold limit is stated in case of GST Act. Under Section 69, there are some powers given, and 133 defines the cognizable offences, non-cognizable offences, and Section 69 talks about the arrest and all. But if supposing that an offence, which is the threshold limit is lesser than a particular amount, is committed in different years, can all the 4 years they add together and make it above 5 crore and make it a cognizable offence? Because any offence that is non-cognizable, it has got a limitation also. As per the CRPC, there is a limitation of 3 years beyond which you cannot prosecute that case. So if the threshold is less, can they add into 4 years together, give a show cause notice and say, say that from 17-18 onwards up to 24-25, you have done 7 crores of tax evasion and then he's arrested? Is that possible? That is one question I want all people that you are dealing with arrest to think about. To my mind, it is not possible because CRPC is very clear that different offences committed in 1 year can be clubbed together. And each offences is not for a period. Offences are not for a period because offence evasion is happening per month, either by a particular invoice or particular month in which the tax is payable. So if he has not paid the tax in a particular tax period of a month, so that becomes one offence. So 3 can be added, or even more can be added in particular year. But when you add all the 5 years together or 7 years together and make it above 5 years, and then you arrest him, so I don't think that is tenable. That is my first point. Secondly, can there be an arrest without an FIR, without a complaint being filed with the magistrate, or without a complaint being filed immediately after the arrest? That is another question that I want, because it is related to this. Suppose they have been given the power to arrest, but can a police officer arrest a person without a complaint being filed, without an FIR being raised, in case of a cognizable offense? So these two things are directly connected to the today's discussion. Other than this, I have fundamental questions about the power to send summons for inquiry. As for the GST, as per the GST Act, the investigations are limited to Section 65 audit, Section 66 special audit, Section 67 power to inspection and search, Section 68 inspection of goods in transit, and Section 71 access to business premises. These are all the places where they can collect information and they can probably do any investigation. But the summon power under Section 70 is given for conducting an inquiry, and in a manner in which a civil court will do. Civil court does send summon to witness only when a plaint is given, a written statement is given, then issues are formed, then both the parties give a list of witnesses, and court issues summon to witnesses, not to parties. So this power to call for witnesses, to evidences as well as document, is akin to that of the CPC, because it has been couched in that language. Section 70 is very clear about it, that he has got the power to summon in a manner that is given in CPC. I will just read that provision. The proper officer under this act shall have power to summon any person whose attendance he considers necessary, either to give evidence or to produce a document or any other thing in an inquiry, in the same manner as provided in the case of civil procedure, civil court under the court provisions of Civil Procedure Code 1908. So, without an inquiry in place, which will necessarily start only with a show cause notice. Without a show cause notice, there cannot be an inquiry, there cannot be two parties. It is an adversarial inquiry, always contemplates an adversarial proceeding in which charge has been told and he has been given the opportunity to defend himself or to reply. So in that case, assessee to whom a show cause notice is issued is a party. He is not a witness. So he can call, after giving a show cause notice to me, he can call anybody else other than me. If I am called and I am questioned, I am interrogated, I am incriminating myself. Natural justice is defeated there itself. When I have to do the cross-examination later, if at all I have to do, whom shall I cross-examine? Shall I cross-examine myself? So this is one question that is very fundamental, and I have written an article on that some time back when I was a student. So this is one that I want all the seniors also to consider deeply, whether this provision of 70 being misused today for the purpose of investigation and implicating and incriminating a person, or to make him admit to his mistake, does it violate or doesn't it violate the principles of natural justice?
Yes, sir. The first point raised by you about the threshold is very relevant. Where to draw the line? Is it year-wise? Then why not it is month-wise? Because tax period is the month for which we file the return. Why it should be a month? Why not? Each assessment, each invoice is an instance. So suppose somebody is clearing the goods, without payment of tax, each clearance is a separate offense. So now what happens is, as you said, multiple offenses are clubbed together to satisfy the threshold requirement. So this is a very valid question, which we maybe in the days to come, it has to be argued in the courts. So thank you, sir, for your inputs. And anybody else want to share any of their inputs? Okay, then once again, thank you, Venkateshwara Perumal, for coming forward and addressing a very difficult subject, I would say, because not all the people who are members of this group may be dealing with the prosecution matters. We deal only with the adjudication, writs, and other things. Only very few people concentrate on prosecution on the tax laws. So thank you once again. So I request all those who have attended today carry the message that we want more and more youngsters to come forward and speak in this forum on the topic of their choice. And I also request all the people, the attendance should be more today. It was somewhere around 32, 34. It's fine for a working day, last working day of the week. But going forward, we should have more participants. So with that, I thank everybody, especially the speaker. And okay, we'll meet again in our next webinar. Thank you.
Thank you so much for giving me the little opportunity to speak in the end. At least I could express myself. Thanks a lot, sir.
Thank you. Thank you, sir.
Thank you, Venkatesh.